Hi everyone, happy Tuesday. Today's Legal 101 is on tax law, of course, and we are going to talk about amounts held in trust for the government. Two such examples are VAT and withholding tax. If you are a business that offers services whose value is more than 5 million, then you are supposed to be a VAT registered person, and when you supply goods or services, you're supposed to issue a tax invoice that factors VAT, which is currently at 16%. That 16%, once the amount is paid to you, does not belong to you. It is supposed to be remitted to the government. There are certain incomes that attract withholding tax. For instance, some insurance commissions, leasing of movable equipment, some professional fees, some management fees, and some fees to artists and entertainers. Now, they will be deducted at the point of payment, so that if person X has earned income out of what I have mentioned, the person who pays them deducts that amount at source. Holding tax certificate will be issued to the payee, okay, as proof that the amount that was deducted was remitted to KRA. Now, if you have received VAT or you withheld tax and you're declared bankrupt or you're liquidated, then these amounts, VAT or withholding tax, do not form part of your estate. In fact, they're supposed to be paid to KRA before any distribution of your assets is done. This is according to Section 34 of the Tax Procedures Act. However, this has to be balanced out with the provisions of the Insolvency Act, and the basic principle under insolvency is that all creditors of the same class must be treated fairly and equally. Now, we have had instances where KRA has gone to court where there's an insolvency matter and said we are actually supposed to be given priority after all, Section 34 provides that where there's amount withheld, then that amount has to be deducted first and foremost before the rest of the creditors are considered. But more often than not, insolvency courts will say that all creditors are to be treated equally. Now, Justice Majanja has said that in two of his cases which I have read regarding Section 34 of the Tax Procedures Act, and in fact he has said unless KRA gives me a good reason why they should obtain preferential treatment, I'm not going to allow them to go before any other creditor, Section 34 notwithstanding. And they have, Justice Majanja also in another case said, it's not a matter of right. I want to see special circumstances. And this doesn't mean that KRA will not get its just due. No. If there's withholding tax to be remitted, it has to be remitted. We are just saying that there has to be procedure. Assets have to be collected where somebody is declared bankrupt. They have to be declared. Creditors have to be brought on board. They have to say, okay, fine, this is how much I am owed. And then there has to be a discussion about who gets what when.